Hello, everyone. Um, Thank you for joining us. This is Chinasa. Thank you, Dawn. I'm seeing DCS. I'm not sure who that is. Thanks, Brandon, for joining. So let me know if you can hear me.
Yes, ma'am, I can hear you.
Okay, awesome. So, how was your week?
I had a good week. I had a great week. I started working. I started working at my new place. So it has been hectic, but very fulfilling. So I'm very happy. So how
Nice.
has your week been?
Very fine. Very fine. Okay. Thank you. So, Dawn is also saying that she can hear. So, thank you very much for joining and for joining early. So we have a guest mentor for today. As you all know, my name is Juliana Imam, and I'll be your anchor for today. This is JIIPCC Mentorship and Internship program, and we mentor law students, law graduates, that's lawyers, young lawyers, and intellectual property enthusiasts, so people who are interested in IP. And this is the second quarter for the year 2021. The first quarter rounded up on the 2nd of April, and this second quarter started on the 16th of April also. We have eight mentees. Six are from Nigeria, one is from Kenya, and one from Nairobi, Namibia, sorry. So today we'll be discussing media and technology law, and Mrs. Chinasa Uwanna will be taking that today. So I hope that everyone has also read about this. Try to ask at least one question. So you can put your question down in the chat box, or you can ask her directly when it's time for us to answer our questions. Just before we start, um, I think three people will make their presentations also today. So we'll just listen to your presentations, and we'll also make the comments on them. So we'll be starting immediately. I'll be reading out the profile of Mrs. Chinasa, and then we'll be continuing from there. Um, okay, uh, hold on. Chinasa Uwanna is a senior associate in the Intellectual Property Law, Technology, Media and Entertainment Practice Group of the Nigerian law firm Banwo and Igoda Law. She has excellent experience in the field and has advised in numerous local as well as cross-border and multi-jurisdictional transactions involving brand registration, transfer, commercialization, protection and enforcement, particularly in Nigeria and other African jurisdictions. She also advises business owners on regulatory issues with particular reference to their IP rights. In addition, her experience cuts across corporate and commercial law transactions, consistently ranked as an expert in the field of IP in Nigeria by Chamber Global Guide and more recently World Trade Mark Review WTR 1000, World Intellectual Property Review Leaders, and Managing IP and Ancillary Issues. She is an active member of many local and international IP associations, including the Pharmaceutical Trademark Group, International Association for the Protection of Intellectual Property Group, AIPPI, the Anti-Counterfeiting Collaboration, ACC Nigeria, Intellectual Property Committee of the Nigerian Bar Association Section on Business Law, the Nigerian International Franchise Association, among others, as well as faculty member of the Africa Franchise Institute. Chinasa has also served of several committees of the International Trademark Association, INTA, including the Africa, Mid East, and South Asia Anti-Counterfeiting Subcommittee and Trademark Reporter Committee. She's also the Nigerian chapter contributor for the Inter-Country Guide on trademark, as well as a contributor to the Future Africa Forum on trade on development and industrialization issues. She has a master's degree in IP law from the University of Turin, WIPO. Um, so you're welcome, Ma. Thank you very much for joining us today.
Thank you very much for this opportunity. Good evening, everybody. It's a pleasure to be here. I have to apologize for not putting on my camera earlier. It's been a very hectic day for me. Thank you for this opportunity to speak with everyone. I want us to be relaxed, and for me, it's going to be more like a chat. Okay, so I'm just going to say a few words, and I'm more interested in hearing what you have to say, about what you're doing. Juliana mentioned that you would be giving some reports. So I look forward to, hearing those reports, and then, us discussing the content. Okay. Today, I'm going to be speaking just generally on, intellectual property, media law, entertainment, and all of that. And I don't expect that we would know everything there is to know once we're done with this chat. Neither do I expect that we would touch on every single thing, but the whole idea is to give some sort of, just speak a little bit about media law, in particular entertainment law, technology, IP generally, and we'll take it from there. I understand I'm supposed to be speaking for just about 10 to 15 minutes. Like I said, I'm more interested in hearing from you, so I would make it brief. And then when we start chatting, perhaps more things will come out from there. Okay? Are we agreed on that?
Yes.
Is that okay? Okay. Thank you. So what's intellectual property? I know that sounds like a funny question to you guys because we've had a lot of conversations around IP. But what is it anyway? What's IP to you? People come with all sorts of bogus definitions and all of that. For me, I always say that intellectual property is all around you. It's everywhere, the chair you sit on, the bed you sleep on, your toothbrush, your toothpaste, the clothes you put on, your handbags, your car, everything. Intellectual property is all around you because it just deals with the creation of the human intellect. It comes from whatever an individual sits down, thinks about, creates, and then, brings about, and people now find useful and use for different reasons. It may just be for the aesthetic reason, it may be for pleasure, it may be for some useful functionality, or so on and so forth. But that's what IP is all about, and that's why it's very interesting to me. And it cuts across everything, from patent law to technology to entertainment to copyright to artificial intelligence and so on and so forth. That's what it's about. But today we'll be talking mostly about media law and entertainment law in particular. And the question is, what's media law? It's that field that relates to legal regulation of a whole lot of industries, including telecommunications, broadcasting, advertising, entertainment, internet, information technology, and so on and so forth. A lot of times when we talk about media law, people think it's just restricted to entertainment law. Whilst that's a huge part of what it is, there are so many other areas and facets to it. So if you're in the advertising industry, for instance, then you talk about media law because advertising is for most people that have sell content and all that, they make their money from the advertisers. If you have content and there's no one advertising, then how do you pay for the viewership and all of that? Then you talk about technology. What's in telecommunications and technology, information technology, that's it. All about the different software applications, different, innovative ways and means of doing things, whether it's in broadcasting or in just, the use of your phones or online and the internet and so on. When you talk about entertainment, the entertainment industry, is actually what is used to describe individuals as well as mass media companies involved in the manufacture and distribution of mass media, content. I can speak mostly to Nigerian law, but I understand that we have people that are not Nigerians here, right? So I'm going to try to keep it as, as wide as, as possible. For entertainment, for entertainment law or entertainment industry, there are a lot of laws that come into place. We have copyright, we have the trademarks, we have patents and designs, and then other things, for instance, that have to do with the company's registration, and maybe even the constitution in some extreme cases are relevant to the entertainment industry. Why is all this conversation, important? The reason for this is that the media industry accounts for billions and billions of dollars. Any economy, any state, any country that doesn't pay attention to the media industry is actually losing out on a lot. There's a lot of money that is attached to advertising, a lot of money attached to entertainment. One has only to look at what happened during 2020, when there were a lot of lockdowns and things like that. Whilst a lot of industries witnessed, a lot of businesses had to shut down, a lot of industries witnessed a downward spiral. The media and entertainment industry boomed. Why? Because people were at home watching TV, people were at home using their phones. I mean, yes, we were at home, but it didn't stop entertainment. It even saw a rise in, all these kids and, younger, different type of comedy and all that. Instead of the usual stand-up comedy and all that, we found that a lot of people started growing and rose to prominence with their skits. And, I don't know if you know all of them, but in Nigeria, I know people like Zach Aloma, Macaroni, and so on and so forth became even more popular because people were still paying attention. And then gradually, if anyone has noticed, you realize that they started, even advertising. A lot of people were using them to advertise and all of that. Content, TV stations like, not stations now, the media stations like Netflix and so on, even the distribution companies witnessed a spike in people subscribing to them, subscriptions and things like that, because this industry is so important and would always be relevant no matter what. So irrespective of lockdown, irrespective of whether the economy is great or not, there would always be need for entertainment. There will always be need for the media to disseminate information, to push your brands out there, to push your IP, and so on and so forth. So, I mean, I'm not going to talk more on this because I see that my 10 minutes is up, or should I keep going? Can I keep going, Judy?
You can speak for another 5 minutes because your speech is very interesting. The topic is very interesting.
Okay, so I'll continue, right? I want to take it that everybody here is a lawyer, right? All the participants are, okay, we're not all lawyers.
About 1 or 2 are not lawyers.
Oh, okay, then I'm not going to go legalese because I was going to start talking about, the implications for lawyers and all of that. Then I'm going to leave that out. But the point is that it's the critical thing I want you to take away from at least this few minutes of my talk is, number one, the media industry is beyond the entertainment industry, okay? It cuts across so many other industries such as telecommunications, technology, broadcasting, and so on. And of course, it still encompasses entertainment, copyright, and so on. The second thing I want you to know is that it's a very, very important industry. It's a multi-million-dollar industry. And it's an industry that we can't afford. I mean, in the present day, we cannot afford to ignore or to do without. Everybody makes use of the media industry. As long as you have a telephone, as long as you have a laptop, as long as you have a television, as long as you have a radio, a wristwatch, whatever it is, somehow you're either connected to the internet, you're looking at advertisements, even outside on billboards and stuff like that. So whether you like it or not, it's a very, very relevant industry, and it's an industry that makes billions of dollars every year. And then the thing is that it's all about intellectual property. In the final analysis, when the chips are down, all of it is IP. All of it is about pushing brands. All of it is about, your performance, actions that you creativity, things that you do that results in, creative acts or actions or inventions or innovations. So at least if that's all you take away from these few minutes, I think you would have gotten something. I think I'll stop here.
Okay, thank you very much, Mr. Chinasa. So what we're going to do now is when I call your name, you would ask one question that is related to what she has just spoken about, and then you have 5 minutes to present your paper on your topic. So Mrs. Chinasa, please, you help us to write down the questions that they would ask you so that once it's time for you to comment, you'd comment on their paper and you also comment on the question that they've asked that is relevant to what you've said. Yes, so I would ask my question first so that you just pen it down and then others would, yes. So for TV stations, we see that if AIT is broadcasting, you can see NTA broadcasting what NTA is broadcasting, then you see NTA somewhere, or if sports news or something, and then you see different stations are streaming what like another channel is streaming. So what type of contracts do they sign for that particular stuff, or is it licensing? What is it that goes on around there? So that's my own question. And then my second question is about the NBC act that was a major issue during the lockdown. What was it really about? Then, so we'll move to Adetola. If you're here, please unmute yourself, ask one question, and then make your presentation in 5 minutes.
Sorry, before Adetola starts. So I'm going to take all the responses at the end, right?
Yes, yes.
Okay.
Thank you. Also, I would like to say that Mr. Marx is also here, so he would also be commenting at the end on the questions and on the presentations. Mr. Marx is a legal practitioner with Everlaw Associates and is also a mentor here. He has been here since the first quarter, so he would also be here to answer questions. You're welcome, Mr. Marx. So we're going to start with
Thank you, Juliana.
Thank you, sir.
And it's great to see Chinasa as well. That's another one of my madams. The people at the top in the well done, ma.
Thank you. Serious. Thank you.
Good to see you.
Okay, so hi Adetola. Can you start by asking your question and making your presentation? If you're not ready, we're going to move. Okay, so let's move to Brandon.
Yes, good evening.
Good evening.
Yes, my name is Brandon from Kenya. I have a question relating to media law. So my question is that how easy, based on your experience, Madam Chinasa, based on your experience, how easy is it to strike a balance between limiting the freedom of the media generally and censorship? For me, it seems like there's a blood line between censorship and a justifiable limitation to the freedom of media. So I would like to get your perspective on how to distinguish the two.
Okay, then you can just go directly to your presentation. You have 5 minutes.
Okay, thank you.
Thank you.
So my presentation is titled NFTs and Copyright.
Would you be sharing the screen?
No, I'm unable to share my screen now.
Okay.
I'll just proceed.
Okay.
So my presentation is titled NFTs and Copyright. I settled on this topic because I particularly would like to hear the perspective of Mr. Marx and Mr. Luko. I don't know if he's with us today.
Mr. Luko is not here today.
Oh, okay. So NFTs and copyright. NFTs are a recently emerging phenomena, and I thought it right to begin by defining NFTs and describing it. So NFTs are digital assets, publicly verifiable and authenticated on a blockchain. They are a type of assets that cannot be exchanged or substituted because they are unique and they have unique attributes that make them different from other types of assets. So the difference between non-fungible assets and fungible assets is that fungible assets can be exchanged or substituted without changing its value. So, for example, if a person gives you 100 naira and you return 250 naira notes, you realize that you've given him something different, but its value it's the same. But now that is the opposite of non-fungible assets. And as you could have seen in the news, maybe NFTs are nowadays applicable in video gaming, especially digital art and even sports memorabilia. So the interplay between NFTs and copyright is that when a person buys NFTs that relates to creative work, be it pictures or videos or even documents, they get two things. They get a copy of that creative work as well as the NFT, which essentially is the digital certificate of authenticity. So we know that copyright is the exclusive right that is granted to a person to control the exploitation of a creative work. So since the sale of an NFT or the purchase of an NFT involves making copies of the creative work and communicating it from one person to another, any unauthorized reproduction or distribution amounts to copyright infringement. So when a person buys NFTs, they get certain rights. And the rights of purchasers generally are subject to the contracts, the purchase contracts. Yes, thank you for sharing the presentation. I was saying that the rights of NFT purchasers with respect to the digital copies of the creative work are determined by the agreements for sale. And in such contracts, we know that parties generally have the freedom to contract. So in some instances, other people are allowed to make commercial use of the uses of the NFTs, but some are not. Some are not allowed to make commercial use. However, there's the Dapper Labs NFT license version, and I would greatly recommend this because it embodies the whole principle of freedom of contracts. So generally, the interplay between ownership of copyright and NFTs is that since NFTs are not regulated, there is no clear regime for regulating NFTs. I felt like the rights of many copyright owners would be infringed on the ground that NFTs are not regulated, and therefore as time goes by, maybe we need to have conversations around the regulation of NFTs in order to protect the rights of copyright owners and even the purchasers of NFTs. So that is my presentation, and I'd like to end it there. Thank you.
Thank you very much, Brandon. So we'll be moving to Rebecca. Is Rebecca here? Okay, yes. So are you ready to make your presentation? Okay, if Rebecca is not ready, then let's hear from Adetola. Rebecca or Dawn. Dawn, if you are here, please, let's hear your question and your presentation.
Good afternoon.
Good afternoon, Dawn.
All right, my question is for entertainment law. I would like to ask Ms. Chinasa. Thank you, Ma, for the lecture. It was really nice. I would like to ask her about, we've noticed over time, we talk about the fact that artists should get lawyers and all, like the information is always out there, but what are some of the challenges that these artists face, and how can we help them overcome them and make sure that they are able to get access to legal services and the entertainment industry in fusion with providing legal services actually grows? That's my question.
Okay, good. So you can go to your presentation. You have 5 minutes, please.
Okay, I would like, please, can you allow me share my screen?
Okay, please hold on. Yes, you can.
Okay. Okay, while I'm at it, let me just start with my presentation. While I'm trying to share my screen. My topic is fast fashion and infringement on fashion designers' rights.
You can start while you're trying to share the screen because of time.
Okay, I said my topic is fast fashion and infringement on fashion designers' rights. All right, so I started off by defining what the term fast fashion is, which is, according to Investopedia, it means it describes a clothing design that moves quickly from the catwalk stores to shops. And these clothes are often based on styles presented at Fashion Week, runway, and allows mainstream consumers to purchase new looks. So an example I talked about in relating it to Nigeria is this popular Aba market or Onitsha market, where we see designer clothes, and sometimes some of these designers haven't shipped their designs into Nigeria or their clothes into Nigeria. But we see that these clothes are sold at ridiculously affordable prices, and we even see these products in the market. So that's it in relation to Nigeria. And the fashion industry is constantly thriving. Over time, we've seen that it's always evolving, and as such, some of these innovations makes it susceptible to IP theft. And this concept of fast fashion, it was actually made to make consumers have access to clothing materials or clothing designs easily, instead of having to wait for different seasons, for example, waiting for a spring collection or for a winter collection. But now they get to have clothes readily available. But it seems like the line has been crossed, because most of these designers spend time trying to create their beautiful designs, but find that these designs are somehow replicated and are being sold in the market, and the quality is way, way low, and the permission of some of these designers are usually not sought. So it's actually a loss to these designers. And then I highlighted some of the ways I think this can be minimized, because I'm of the opinion that it might be very difficult to actually completely eradicate this trend of this fast fashion trends. But I feel it can be a little bit minimized by firstly conducting searches at the registry to ensure that by designers, that their clothing lines do not infringe on third parties. So they know, okay, they are bringing something different, something new to the table. And then after bringing these designs, they have to ensure that they register it, irrespective of how short the trend may be, because over time we've seen with fashion that clothes are always in trend. Particular clothing can be in trends today, and by next month, next 2 months, next year, say that something else has come up. But I feel designers should not be discouraged with the whole trend thing and decide not to register their designs, feeling probably, oh, this thing might go out of fashion next how many months, or is there really a need spending that money on design? I feel there is actually a need, because it's beginning to seem like some of the clothing designs we had 10, 20 years ago, they are beginning to come back into fashion. So it would be really wise for them to register their designs, and then they should put license their design, grant licensing to persons who want to actually remake this product, so they get to benefit. And then also have confidentiality agreements with third parties, because sometimes it might be somebody that is close that would actually give others some of their designs or the framework of how to get this product out into the market. So to protect their designs or their intellectual property, they should put out licensing and then confidentiality agreements. And then they should always keep an eye in the market for counterfeit design. So that way you always know when somebody replicates your work without your permission, you are able to stop the damage to your reputation or to your design. And also they can sue those who infringe on their rights. And I feel fast fashion is an area that should be looked into, because designers suffer monetary loss and also intellectual property theft, which is way worse, because I saw a movie recently and where a designer's work was replicated without her permission. And although it wasn't so bad, but the mental effect it had was really glaring, because you could see that somebody sat down and designed something, and then you find out that, oh, somebody else has just started making money with your product, somebody else has just replicated your designs in a different way, in really, really low quality form. So I feel that this area is something that should be looked into, even as fashion law is evolving now. Thank you.
Thank you very much, Don. Okay, so is Adetola ready? Okay, if Adetola is not ready, then we'll just move to Sewese. Okay, Paul, are you here? say Paul, Daniel.
Okay, I'm
Yeah.
here, ma. Can you hear me?
Okay. Who is speaking now?
Yes, I'm Paul. I'm here.
What about the lady?
Okay.
Sorry, your name is not written.
Sewese.
Okay, say. So you can just ask your question and then you make your presentation.
Okay. Good evening, everyone. Thank you again for this opportunity. Thank you, Ma, for your presentation, even though I didn't follow through to the end because I had network issues. Okay, so I'll be asking the question. I don't know if this was addressed during your presentation. For a young lawyer trying to develop a career in the field of media and technology law, IP generally, are there any particular skill sets required for one to be successful in that area? Okay, so that would be my question.
Okay, you can just move straight to your presentation.
Okay, so I'll be presenting on alternative dispute resolution and intellectual property disputes. Okay, so I chose this topic because I feel it is ripe. The time is ripe for this to be looked into. Alternative dispute resolution has become the new normal. It's most persons are familiar with it, but the applicability is an issue. So most of the time when disputes arise, you find parties resorting to litigation in order to resolve such disputes instead of availing themselves of the numerous advantages that alternative dispute has. Okay, so I'll be explaining what alternative dispute means briefly. So it simply means the use of less formal methods other than litigation to resolve disputes. So alternative dispute methods include arbitration, negotiation, mediation, conciliation, neutral evaluation, so many of them. These are just a few examples. And it has a lot of advantages. So with alternative dispute resolution, there's flexibility there because you wouldn't have to go through that formal court setting. And then there's also, it's time saving, it's also cost effective. And then above all, it preserves or promotes a harmonious coexistence amongst disputing parties. So having looked at the major types of methods of alternative dispute resolution, I'd like to also relate it to intellectual property. So in resolving intellectual property disputes, there are so many areas where we can apply alternative dispute resolution in areas such as copyright, software, patents, trademarks, trade secrets, licensing disputes, unfair competition, and so many other areas. We can apply alternative dispute resolution. And the outcome, the good thing about alternative dispute resolution is it allows for, apart from an amicable resolution between parties, it also allows for privacy. So with so many, especially IP, there is a need to preserve trade secrets and all of that. So alternative dispute resolution affords disputing parties that opportunity to preserve trade secrets because it's more of a private setting, it's not public as litigation would be. And then for instance, okay, so having looked at areas where we can apply alternative dispute resolution, for a lawyer, an IP practitioner, you might be asking, okay, so I have so many methods under alternative dispute resolution, which method would be applicable to a particular dispute and all of that? So many methods have proved effective in the past. Arbitration is one of them, mediation, and so many others. So in my own view, I would recommend mediation. And I've gone ahead to explain briefly what mediation means. So it's simply a voluntary or involuntary non-binding process facilitated by a neutral third party.
Okay, are you still there? Sewese. Hi, Sewese, are you still there? Okay, I think she was almost done with the presentation, so um, that's fine. We can move to Paul or Adetola. Paul or Adetola.
Can you hear me, ma'am?
Yes, I can hear
Okay.
you. So you can quickly round up because of time.
Okay. Okay. All right, ma. Thank you. Okay, so I'll say mediation is simply a process facilitated by a third party and to assist disputing parties to come to an amicable resolution, an amicable agreement, and it offers a lot of the alternative dispute resolution. So I feel the time for ADR is now, especially in Nigeria at the moment with the ongoing JIIPCC strike. I don't think lawyers are finding it funny and all of that. So I remember also, I think Brandon, when he was presenting on the effects of COVID-19 2 weeks back, he also mentioned litigation as one of the disadvantages and all of that. Access to litigation, sorry. So I'll recommend ADR at the moment, and I will conclude with a quote by Justice Warren Burger of the US Supreme Court. And he says that the notion that ordinary people want black robe judges and well-dressed lawyers and fine courtroom settings to resolve their disputes is not correct. People with problems are like people with pains, and they want relief, and what they want is quick and relief that is quick and inexpensive as possible. So I will just close with that. ADR is right now, and I think we should key into it.
Thank you, Sewe. Thank you very much. So we'll take one more presentation and then we'll allow our mentor to, both mentors to comment on them. So either Adetola or Paul should make their presentation.
To make my presentation.
Okay, so you can ask your question and
Presentation.
yes. You have 5 minutes, please. We can't
Hello.
hear you, Paul. Yes, please ask your question and move straight to your presentation.
Okay. My question. Thank you very much for this opportunity. First of all, good afternoon, everybody. My question is with the effect of technology to the media as it is in the present day, I think the technology has been has affected the economic profitability of creative works of artists, and it has also done good, but I feel it has done some harm. So my question is, how can these harms be curbed, reduced, minimized, or probably eliminated? So that's my question, and I'll be moving on to my presentation. My presentation is on the challenges of small businesses. The challenges of small businesses on intellectual property. Now,
Sorry, I'm
the reason I am
sorry.
making
I'm so sorry, please. I'm not sure I got your question well.
Okay.
Sorry to take you
My
back.
question is, yes, Sorry. My question is, I think technology has done more good than bad in the present day as regards to media. My question now is this. Okay, now for example, we know about the idea of sharing music, downloading videos and stuff like that, and sharing them. There are sites that provide these things free of charge, and there are sites that I know it's not really exactly what your presentation was about, but I have had this confusion for a while now. And since you talked about media and technology, my question now is, how can this effect be curbed, or how can they be eliminated? Sorry, I don't know if you get that now.
I think so.
Thank you very much, Ma. Thank you, Ma. Okay, so moving on to my presentation. My presentation is on the challenges of small businesses as regards intellectual property. Challenges of small businesses as regards intellectual property. I'm actually making this presentation because it was Intellectual Property Day on the 24th. On the 24th, officially celebrated on the 26th. And I could not make my presentation on this because of the last meeting scheduled. And so I'll be making it today. And I'll be talking about the challenges of small businesses. Now, small businesses can be understood to simply mean businesses that operate on small scale. I think that's like the most reasonable explanation for a small business. Businesses that operate on a small scale, businesses that operate with small fundings, businesses that operate with limited funds, limited employees, limited time. This is what I understand to be a small business. Now, most small businesses are more concerned about their day-to-day operations. Most small businesses are more concerned about making profit, saving money, and any need for spending money would seem as not worth it, in quote. Any need for spending money would not really appeal to them. Most small businesses are all about spending money, making money and saving money. And so I'm going to move on to the challenges as regards intellectual property. Now, first of all, I think one of the challenges for small businesses as regards intellectual property is the understanding of intellectual property and the need to protect it. The understanding of intellectual property and the need to protect it. Now, there are a lot of misconception about the term intellectual properties by small businesses, especially run by illiterates or run by people who are not so conversant with legal terminologies or are not just experts in the field. There are lots of misconception about this, and before I think I had the same understanding before I started. I was taught about intellectual property, or I started making my findings into intellectual property. Intellectual property is mostly understood to be on a particular product name, or on a brand name, or on a particular design or something. But most times they do not understand that intellectual property has to do with every creation of the mind. Intellectual property has to do with everything that the mind creates. If your mind creates anything as regards your business, it's an intellectual property to your business. Since it is yours, and you should protect it. Intellectual property, for example, includes branding, your packaging, the processes involved in making that your product, your website, your domain and your content, your website domain and content, the product itself, and every other product of your mind is your intellectual property. And so most of the times people do not understand this, and with a lot of misconception, they feel only the name or probably something else is what their intellectual property is. And so the processes of because these other products or do not really, these other processes, like thinking about the processes, thinking about branding and packaging, a lot of people do not really assert their mind to the fact that this contributes to a lot of people do not assert their mind to the fact that this contributes to their sales, to their profit making. And so they are only concerned about the day-to-day operation, about selling and buying. And so they feel this is not worth it. In quote, what I mean is they feel this is not intellectual property per se. This is not intellectual property per se. What they feel is the intellectual property is the product itself, the one they created, and the name of the product. Not knowing that your packaging, your branding, and every other thing aside that you created with your mind is your intellectual property. Now, moving on, one other challenge faced by small businesses is insufficient information on the relevance of IP. Most people do not understand the relevance of IP, and most people do not understand that IP is an asset. Your intellectual property is your asset. They do not understand the value of your IP. Like I said earlier, most people care about making more money and saving money. Any idea about spending money, especially to items not directly contributing to the profit, would seem like a waste. Now, small businesses often have very insufficient knowledge about the relevance of IP to the day-to-day businesses, in their day-to-day business.
Can you hurry up? Your time is up.
Okay,
Can
I'll
you
be
just
rounding up now.
Okay.
Okay, the high cost associated with enforcing your intellectual property right, the high cost involved with registering your intellectual property rights, as most businesses are always limited in terms of finance or funds, is one of the challenges. Another challenge is most people feel that protecting your IP rights can be esoteric, can be cumbersome, it can be time consuming, especially when as regards trending products or products that can easily be developed, reproduced, or go out of trends. So SMEs face a number of difficulties in using IP system. This is often the result of their limited knowledge of the ins and outs of the IP system, lack of clarity about the relevance of the business strategy and competitiveness, and of their findings. The system is complex and expensive to use. Available system of the use of the IP system by SMEs are largely limited to the use of patent. Thank you very much.
Thank you very much, Paul, for your presentation. So I will just give an exception to Adetola or to Rebecca to present. And why I want them to present is because they were among the first people to submit. So please, I want just one of you to do that. So the first person to actually go for it, Adetola or Rebecca.
Good evening.
Okay, two of you are presenting at the same time. Let's just hear from Rebecca since she started first. Then we might still get back to you, Adetola. Okay, so Rebecca, quickly ask a question.
Okay,
You have 5 minutes.
Can you hear me?
Yes.
Okay. My question, as regarding, I wasn't around during the lecture, but I saw the slides you said on the group chat. So I have just one question regarding social media marketing. Is there any sort of protection for intellectual property put out by social media marketers? Because from my understanding, from my research, there is no concrete law that covers the copyright I talked about was casting, but I do not think that social media fits into the channels that protection is provided for. So is there any regime, is there any sort of protection for intellectual property disseminated via social media?
Okay. So you can move to your presentation.
Okay, my presentation. Please, I won't be able to share my screen if you could, please. I'm in transit, so I'm not on my laptop. Okay, so my presentation, my topic for this week was differentiating between software and computer programs and examining what protection, intellectual property protection are available to them in Nigeria. And the most popular, as we all know, is copyright. Copyright Act talks about programs. But from my report, you notice I drew a distinction between software and computer programs. Okay, what most people do is use both words interchangeably, but when it comes to information communication technology or the tech world in general, there is a huge difference between software and computer programs. Computer programs are a component of the software. The software has to do with how a set of computer programs that are put together function, how they function, and it includes the look, the code, and everything. The computer programs, on the other hand, have to do with short instructions that are written by a programmer. That's what we call the code, numbers, and words. So obviously, being literal, it falls under what can be copyrighted. But then software, there are no codes, there's no writing, it's a function, it's a process. That tells us that, okay, patents can cover software. But unfortunately, we get to see that most lawyers are arguing that software is protected either by copyright or by patents. Very few people have the opinion, by the way. Most people think there is no protection for software, and others think the protection available for software is under the Copyright Act. But no. So if we were to look at these two terms technically, we find that two different concepts are in play here, and two different modes of protection, intellectual property protection, are in play. And that's why it's difficult for us as lawyers to explain these programmers, because they understand the difference. So when you are telling a programmer that I can copyright your code, and he's wondering, so what of the future of my mobile application? The future of my mobile application is not just the code. How do I protect that? And in this era where most companies, most businesses are beginning to develop mobile applications for their products and for their services, and we see a lot of copying around. You find one app doing this, having this feature, and in a few months there's another app having the same feature. That tells us that this sector, the industry, is very open. It's at risk of experiencing intellectual property violations. And I've seen a lot of programmers who actually want to understand what they can protect, how they can protect these things, and understand the difference. That's why I try to choose this topic. And I think it's high time we remove our minds from just protecting computer programs as with copyright rather, because there is just how much you can protect the code. In the world of programmers, a lot of codes are going around, it becomes like general knowledge. So some codes are available for public use. So there is not much right to protect. It's not inventive, it's not new, there's not much right to protect. But what they really try to protect is the function that their mobile application or their software provides. So I think that's the most important thing to software developers. That's the most important thing businesses are using software. So that's where we should be channeling our attention to. But in either case, if we are going to talk about computer programs and software, then we should be looking at them as two separate concepts rather than using them interchangeably, because it's not obtainable in ICT. That's
Okay. Thank you very much, Rebecca. Adetola, are you ready?
Yes, I
Adetola.
am. Good evening.
Okay.
Can you hear me?
Yes, we can hear you. Quickly ask your question.
Okay. My name is Aditola Jislemi. I'm a okay. My question is bordering on technology law, mostly. So I read somewhere that Sophia the robot sold its NFT, that is a self-portrait, for more than say $600,000. Now I'm curious, who gets to keep the money? Is it the company or Anton or Sophia itself that gets to keep the money, or even who owns the artwork? So that's my question. Is budging more on intellectual property and IP law? Can I
Sorry,
go ahead
who
with
owns
my
it?
presentation?
Can you repeat that? Hello?
Hello, Adetola.
Can you take your
Yeah,
question again?
yes. Okay. Um, okay, let me take my question again. I said, I read somewhere that Sophia the robot sold this NFT, that is a self-portrait, for more than say $600,000. Now I'm just curious to know who gets to keep the money, or should I say who owns the artwork? Who gets to keep the money? I mean, is it Sophia or the company itself, or even Anton that gets to keep the money? The proceeds from the sale. That's my question.
Okay.
Yeah. Okay. Now, on to my presentation. My topic is the African tech space and intellectual property. Now, in recent years, Africa's tech sector has been booming. It has experienced steady growth and investments. But findings and research show that this growth will have been more if there were the right IP laws in place. And as we all know, there's still piracy, especially even in Nigeria, as we don't have the original genuine Windows. Everybody's using the counterfeit, or almost everyone is using the counterfeit or the fake. Now, according to PwC, countries with lax intellectual property laws struggle to attract foreign direct investments and then grow their innovation, research, and technology sector. Now, I felt, okay, let's write an article that will border more on what can be done to improve to improve Africa's IP sector. Now, first, I believe the first responsibility should be on to the to startups. Like, they should prepare for the long term, that is hire a good IP management team, have long-term IP strategies in place, and all of that. Then yeah, African governments should also support startups and provide them with the necessary resources they need. That's the first point. Now, the second one, I believe there should be more IP knowledge and education. It should be more promoted. Everyone should know what IP laws are and what startup needs to do to protect their intellectual property. The second one is there should be more cooperation between academia, industry, and governments in order to raise awareness of the economic benefits of intellectual property laws. Now, the last point, that's the fourth one, is to educate the public about the value of patents and how they can be protected. I believe if you do this more, I believe gradually our IP tech, the tech and IP sector in Africa will be boom in a way. So yeah, that is the end of my presentation.
Thank you very much. Daniel, are you here? Daniel.
Okay, I am.
Oh,
Good afternoon.
Quickly ask your question. And I called you last because you submitted your question, your assignment last. The next time you submit it last, you will not present that day.
Okay, ma. Thank you, ma.
From me to you. All right.
Yes. Thank you, ma. My question is, I want to ask that when social media creators, like for instance, Macaroni and the like, social media comedians, when they make skits for companies, like when they do adverts for companies, sometimes they make skit for a particular company. I want to ask that who owns the intellectual property to that skit? Will it be the company, or will it be the social media comedian, or do they have to have an agreement that would determine the ownership of the IP of that creation? That's my question to Mrs. To the to our presenter. I don't know if you got my question.
Hopefully, because if she didn't get it, she would have commented. So you can just go straight to your presentation.
Okay, my presentation. I don't
You
think I'll
have
be
5
sharing
minutes.
I don't think I'll be sharing my slide. But I want to talk about the recent waiver or the recent support by the Biden administration for COVID, for the IP rights on the COVID vaccines, and possibly looking at the role of the WTO. Okay, I believe that for me, when I read that, when I saw the waiver, I said to take a look at it. There was a recent announcement by the Biden administration that they were support of the WTO's negotiation on waiver or suspension of IP protection for COVID-19 vaccines. And of course, the big pharma companies have kicked against this proposal, and it was not well received in the sector. And they've kicked against it in the past. I think this discussion came up last year, but South Africa and India recently submitted a proposal for the waiver or the temporary waiver of IP protection. Of course, we know what that would do to them. So I decided to look at, although I looked at patents itself, but I decided to look at the agreements that most of these countries entered into. For instance, we have the agreement that governs IP protection internationally. Not that this agreement actually provides for international patent rights. What it did is that it just provided for a benchmark or a threshold of patent protection, of not only patent, of IP protection in the world. So article, let me just quickly I also stated that this agreement is binding is binding on countries that ratify the agreement. And this agreement is no other than the trade-related aspect of intellectual property rights, known as TRIPS agreement. It's only binding on WTO members and those who have ratified the agreement. Now, for Nigeria, for instance, this agreement will only be binding on Nigeria if Nigeria has domesticated this agreement in accordance with Section 12, sub 1 of the 1999 Constitution, that provides that the National Assembly would domesticate the treaty. So going forward, I also looked at the aspect of the agreement. So I'm trying to the preamble of the article provides that patent rights or intellectual property rights is a private right. Then also Article 27, because I'm looking at patents specifically, provides that patents shall be available for inventions as long as it satisfies the essential conditions. We all know the conditions of patents because of the time, because of the limited time. Then Article 31 of the agreement now permits member states to authorize the use or other use of patent rights without the consent of the holder of such rights. So I believe that it is based on this article that the US has decided to support the waiver for the temporary waiver or suspension of the IP rights on COVID-19 vaccines. And it's provided the following circumstances. One, where the patent holder has approached the patents, where the patent holder has been approached for a voluntary license on reasonable commercial terms and conditions, but the patent holder has not granted or did not grant the voluntary license within a reasonable time. Then two, in cases of national emergency or extreme urgency or for public non-commercial use. Now, Article 31 also provides that the right holder shall be compensated or shall be paid adequate remuneration in the above cases, taking into account the economic value that has been put into the authorization. Now, I've also said that, and one thing that the agreement did was that it gave or it vests the member states with apart from providing the threshold, it also vests the member states with the appropriate mechanism, or it provides that the member states are the determinants, or we don't want to determine the appropriate mechanism to implement the agreement. It also provides that the member states can extend the agreement, but the in their respective IP laws, but their respective IP laws must not contravene the provisions of the truth agreement. So in other words, the truth agreement should be the benchmark, the minimum protection, IP protection for patent rights. So it seems that from the agreement, there's nothing, because some people are asking, is there anything like international patent rights? There's nothing like international patent rights. Patent rights is territorial. Furthermore, I also looked at the fact that there was the Doha Declaration of 2001, where member states affirmed that flexibility in circumventing or in suspending patent rights for easy access to essential medicine. So in other words, the recent support by the Biden administration is, for me, is a right step, and it is in line with the Doha Declaration. So I concluded that now from the foregoing, it's clear that WTO's role in the negotiation is determined or is hinged on the decision of the WTO member states, whether or not, especially the developed countries, whether or not they will agree to the suspension of patent rights on COVID-19 vaccines for the purpose of public health, or for the purpose of ramping up the mass production of COVID-19 vaccines. So I believe, in my opinion, that the decision by the United States government is a right step, and it's laudable and commendable, and other developed countries should also emulate same.
Thanks very much, Daniel. So everybody have successfully presented and asked their question. So I'll be calling on Mrs. Chinasa to start with her response to the presentations and to the questions, and then Mr. Marx will also make his comments.
Hello, everybody, once again. Well done. You know, this is my first time to be in this kind of setting or setup. I work with law students and lawyers and all that, but not on this kind of one-on-one mentor-mentee setup, and it's really interesting. And you have actually covered a wide range of issues, you know, from fashion to technology to SMEs and all that, and I think you've done pretty well. If I may, I don't really know what your presentations have been like in the past, or your reports. I would suggest that you consider maybe a PowerPoint presentation style. I don't know if that is workable, because for some of the papers I looked at, I was struggling to see what was written. I couldn't really make out, so I had to pay particular attention to what was being said. And honestly, I did miss one or two things along the line, you know, but it would be helpful if it's in presentation format, then we can share our screens and everyone can, you know, flow together. Okay, I don't know, I don't want to rock the boat, but I'm just
fine.
Mm-hmm.
Very good.
There were one or two, I don't know, I don't think I can respond to every single paper or report, but there are one or two that I just made some notes on, and I was going to just quickly say the issue of computer programs, for instance, and protecting how copyright is insufficient protection for computer programs. I thoroughly agree with that. In some other jurisdictions, like in the US and so on, they have provision for patents for computer programs and all that. And that's why you find the technology companies, you know, waxing so strong and all that. In some other jurisdictions, like in Nigeria, we have copyright protection only for computer programs. But the problem with copyright is that copyrights can be improved upon to create a new set of rights. Okay, so once you disclose what it is that you've done, you know, someone can look at it, tweak it a little bit, and create another product or another work that will be eligible for copyright protection as well. And so the danger, for instance, in revealing what your source code is, So you want to get protection. For instance, the notification scheme that is run in Nigeria, where you disclose your source code, and someone can use that source code and still achieve the same technical results using a different source code, not the one you have disclosed. And that source code will be eligible for copyright protection. So I thoroughly agree that copyright protection is not necessarily the best form of protection for computer programs and software. However, it also depends on what it is you're protecting. For source code, no. But when you talk about the GUI, the user interface and all that, it can be protected by copyright, and it can be very distinct, such that anyone that attempts to copy something similar or so would be seen to have infringed on that right. I also wanted to say something about the SMEs, the small and medium-sized enterprises. I thoroughly agree again that it's time people began to see things beyond, I just have a business or just my trademark or whatever, and look at the IP aspects of the whole business, right? And which is why, for instance, the World of Intellectual Property Organization chose that theme this year to celebrate SMEs, which account for the bulk of the creativity that we see in the world today, and even for job opportunities, employment opportunities, and all that. Without the SMEs, without those people who, take time. In my firm, we talked about, during the World IB Day, we talked about a light bulb moment that ends up being what, rules the world, because it starts with a small idea, a small business, but before you know what's happening, it has exploded into, an innovation, an invention, something that is useful for generations to come. Okay, there was I made a few other notes, but I don't know if I have time for all of that. Maybe I should just go into the questions that were asked. Okay, I will just start by responding to the questions. And if you don't mind, I jotted some of them down. So I will just quickly look at what I have and respond. There's a question that was in the Q&A in the chat box that said, what category of IP products enjoy IP in perpetuity? And my response to that would be, most IP is time-bound or subject to renewal and all of that, apart from maybe trademarks, and in certain cases, trade secrets, if you're able to keep your trade secret secret, okay? For patents, in most jurisdictions, it's for 20 years. A few jurisdictions would extend to an additional 5 years, making 25 years, but in most jurisdictions, it's 20 years, subject to annual renewal, after which it will lapse, that it's going to public domain, and then it becomes free for all. For copyright, most copyright is for the life of the person. It depends on which country, sometimes 70, on which country and what type of work. It could be 70 years after the death of the author, or 50 years after the death of the author, and so on and so forth, after which it will lapse. For other types of IP, it's the same thing. Designs in Nigeria, designs you can't protect a design, industrial design, for more than 15 years. But for your trademarks, it's actually in perpetuity as long as you continue to renew. So I've had cause to deal with some trademarks that were filed 1960 something, or and it's crazy. They renewed and renewed, and particularly the very famous, or very for multinationals and all of that. Up till now, they still have their trademarks and they're still renewing them. So, for instance, the Coca-Cola bottle design, which is surprisingly registered both as a design and as a trademark, has been renewed for so many years up till now. So most categories of IP would lapse, except trademarks, as long as they're renewed, and then trade secrets. But the problem with trade secrets, as you know, is that once the secret is no longer secret, then you don't have any protection anymore. Another question that we had in the box was, is there any form of IP protection for social media marketing, right? I am not quite sure what you mean by social media marketing. If you mean, for instance, content that is, displayed on social media, I would say then you have copyright protection for that. As I expect you know, copyright is if any work that is original and is fixed is eligible for copyright protection. What does originality mean? Originality just simply means it's new, no one has done it before, or it's an improvement on something that already existed or something like that. And it's fixed. Fixed means that you've put it in a particular format, you know? So for something you have already put on social media, if it is your original work and you put it up on social media, then it qualifies for copyright protection. So I would say copyright is the kind of protection you can get. Okay, and you know that copyright is automatic. So, because some people used to worry, oh, I didn't register it, I haven't gone to the NCC, I haven't gone to deposit it anywhere, or I haven't paid fees to get a certificate. Whilst all of those things are important, copyright is automatic once a work is original and is fixed. Okay. I want to assume that you understand what fixation means and originality. So that's the form of protection you can get for social media content. Now, if you're talking about marketing, because social media marketing could also mean something different, you know, like maybe you have something for sale and you put it up there and all that. I would say it depends on the social media that you are using. Okay, most of these different, whether it's Facebook, Instagram, whatever it is, have their terms of usage and things like that, and their guidelines as to how you market products, you know. And then obviously, depending on the jurisdiction, even though that's a bit dicey because social media is ubiquitous, but depending on jurisdiction, your advertising laws might have some relevance in that case. Then another question we have is, let me just go up. What challenges are faced by artists and how can we overcome them and ensure that they get access to legal services? I assume that this is artists with an E, you know, but anyway, it's something that would, you know, cover everybody in the creative field. For artists, I would say the major challenge that they have is ignorance. A lot of these artists don't really understand intellectual property. It is just that, oh, this person is gifted, you have, you can sing, you can act, you can draw, you can sew, you can paint, you know, whether in the fashion field or music or drama, film, or whatever. Many of these artists don't really understand what they carry. They don't really appreciate the kind of rights that they have. So a lot of times they just enter into all sorts of agreements without even having a proper understanding of what they're entering into. So I've seen some artists in my experience that, you know, signed with some production company and all that, and basically sign away all their rights, you know, at the point of, because they're just excited about, oh, so-and-so company is willing to sign me on or something like that. And at that point they sign, oh, I'm not going to work with any other person. I'm not going to do this. I'm not going to do a gig without your permission. I'm not, you know, by the time you look at the kind of agreement they've signed, realize that they've boxed themselves in, you know, so tight. So the first thing is ignorance. They don't even understand the kind of IP they have. And even when they have that IP, they don't even understand who owns what, you know. So even when there are no agreements per se, the artists deal, you know, they enter into, they do their work without really knowing the extent of rights that they have and how they can maximize and use that and use them. And so that's one of the major challenges they have. And when you talk about how do they get access to legal services, one other thing I would say, and this is now based on my experience, is that a lot of artists also feel that they don't need legal representation. You know, I've dealt with so many people that feel that, oh, my younger brother is a lawyer, oh, my friend just graduated from law school, or one thing, you know, they don't realize that the fact that you're a lawyer doesn't necessarily mean that you appreciate or you fully understand a particular field of law. You know, I don't, for instance, claim to be an expert in shipping and maritime. I may know certain things, in that regard, but I wouldn't claim to be an expert because that's not where I focus. That's not my, area of expertise. And so if I'm advising someone who has, a ship that has been that has been stopped or something like arrested, I may not give the best sort of advice as much as if I was advising someone that had an IP issue. Okay, it's for them to, I guess we need a paradigm shift where people begin to understand that you need the lawyer with the right skill sets to guide you along the way. And, from the beginning, not when you enter into trouble. And then the lawyer now tries to, make amends. That's unraveling something that is so complicated. But from the beginning, before you start negotiation, before you do any gig, before you sign any book contract, before you go to any, whatever it is, gig that you have, let you get a lawyer. And it's not as expensive as you think, which is another thing, because a lot of artists always think that, oh, if I go and get a lawyer, I'm going to spend so much money, this and that. It's not necessary. In fact, the bulk of the work we've been doing for a lot of people in the entertainment space has been what I would even consider almost pro bono, because you can't even charge as much fees as you would charge for some other some other type of work. Excuse me. There's a lot that can be said on that, but let me just move on to another question. Skill set. Okay, there was a question about where one broadcasting station uses news earlier reported by another station. In my opinion, this would fall under fair dealing, or fair use, as the case may be, depending on whether the other station is given credits for the news. Okay, so if, for instance, like the example that was given, I can't remember who asked this question, you have channels, television reporting news that was earlier reported by CNN. As long as you can still see the CNN sign up there, it's clear that you're not saying this is you that reported it, right? It's CNN's news and you're just reporting it. But it's a different thing if you take what is not news, let's say a television show or program or content that has been created by someone else, and you broadcast it or you stream it without, due license. So in this case, you would need to get some sort of license agreement, or permission or authorization to do so. But if it is news, I think news falls under the category of fair dealing. So you are just reporting, for the purpose of information or education, or as the case may be. I'm trying to see if there's any other question that I have left out. There's a question on the NBC, I'll come to that, and striking a balance between limiting the freedom of the media. Please let me know if there's any question that I haven't attended to. Otherwise, I would continue. Okay, so on the NBC issue, right? It's basically about the Nigerian Broadcasting Code, right? Sometime in 2020, the question is what was the NBC issue all about, right? So that's what I'm answering now. The Minister of Information and Culture, Hadlai Mohammed, he launched a revised or an amended Nigerian Broadcasting Code, and that code, was to the effect that it was going to amend the 6th edition of the NBC code as the existing one, the previous one. And the new provisions were subject of debate. In particular, the amended code incorporated antitrust provisions that prohibited exclusive agreements for sporting and other broadcasting rights, among others. There's increase in fine on hate speech. There were provisions that sought to regulate broadcasting of news and all that. There was something about, you cannot broadcast news that is embarrassing to the government and all of that. So to a large extent, there were so many provisions that were introduced that did not sit down well with the media companies, and indeed most media practitioners and all that, and so there was pushback on that. I am of the opinion, and this is my own personal opinion, I am of the opinion that the powers that were exercised by the minister were not properly exercised, but that's not the subject of today's conversation, and well, so that's where we're at. I'm not aware that anything much has been done. There's been petitions, there's been, people that have agitated against it and all that, because it was seen as kind of stifling the freedom of the media. And indeed, I don't know how many of you followed the news during the NSAS protests in Nigeria. There was some reports by some media companies like I think Channels, maybe AIT, and another one, I can't remember which ones, and they were actually fined or something by the government for reporting certain pieces of news regarding the NSAS movement. For a lot of us, a lot of practitioners, we see it as a weight that, because there's also the question about how do you strike a balance between regulating it and, having the freedom of media, that really, the media should be free. I don't see that there's any other way around it. I know there are people that believe, regulate the media, this and that, but I'm of the opinion that if you start regulating the media, the question is how far would you go in regulating them? Then doesn't mean that they cannot, publish information or news as it comes. So before any piece of information is going to go up, for instance, you start thinking, is this going to embarrass the government? Is it going to embarrass individuals? Is it going to cause a panic in the state? So how do you now really, report what's going on? How do you have that freedom to go, and let people see this is what happened in Maiduguri, this is what happened in Jos, this is what happened in Nigeria, in Imo State or in Lagos or Ilorin or wherever, as the case may be. So for me, I don't see that balance. I don't know how that balance is going to be struck, and this is my personal view. I think I've pretty much covered the questions I had noted. There was something about a skill set for a lawyer interested in developing a career in IP. And I would say that it's pretty much the same kind of skill set that any serious lawyer should have. You should be knowledgeable, you should know the law. That's the first step. And, there's this thing about, God forbid that a lawyer should know all the law. Perhaps you shouldn't know every single thing, but you should know the law. You should know enough to have a conversation, an articulate conversation on any topic, particularly now that people now specialize in different areas. So if you say you're going to do intellectual property, then you should know enough about intellectual property to be able to speak to intellectual property and different areas of intellectual property. It's not enough to just know the basics like every other person. What's a trademark? What's this? How do you file that? You should know, you should examine, do short courses. Learn more. I'm always an advocate of going to go and do courses. And, the WIPO has made it so easy. For instance, World Intellectual Property Organization Academy. There are so many courses on a wide variety of IP subjects, from geographical indications to trademarks to patents to, the Madrid system of filing to collective management of copyright to, artificial intelligence. There's so much that and a lot of these courses are free. Some of them are not free, but, the cost is not, too cumbersome as well. Know the law. That's the first step. Read up and all that, practice, and, ask questions, make it like what you are doing now, for instance, being a mentee in a program like this. These are the kind of things that help to build you up. The skill sets you need, you have to be smart, you have to be inquisitive, you have to look out for new opportunities, know what's going on around you, ask questions and all that, follow the development of the law and so on and so forth. Yeah, there was a question about Sophia the robot as well. I just saw that again in the chat box. Recently, Sophia the robot sold its NFT self-portrait for more than $600. I'm curious to know who gets to keep the money, the company or David Hansen or, or Sophia. I would say that I'm also curious to know. I really don't know. I guess it depends. It depends on whatever arrangements, or if there are any agreements and all of that between the company and, so who owns Sophia now? Is it the company? But then that portrait was a joint portrait. It wasn't just Sophia. I understand she did it together with someone, right? So possibly you say they co-own the portraits and all that. I don't know. Honestly, I cannot say. But I would say that because this artificial intelligence is a really funny thing. Possibly the company and the other guy who worked on it. But then again, it depends. If there's some agreement or some written document that states that anything created by Sophia belongs to the company, blah, 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 then it probably be the company that owns it, okay? Otherwise, it could be co-owned by Sophia. But then the point is, excuse me, can a robot own how would I put it? Own stuff? Can a robot be entitled to money, to payment, and things like that? These are all things that I would say, like a lawyer, it depends. It depends on the agreement, it depends on the setup, and so on, okay? But again, like I said, I'm curious to know, and it's something worth investigating further. I think that's pretty much sums it up.
Thank you so much, Ma. You have actually said a lot, and we've learned a lot. So I'll just move to Mr. Marx to also give his comments.
Okay, I hope you can hear me now.
Yes, we can, but we would like you to increase your volume a bit.
Okay, is this better now?
Yes, sir.
Okay, thank you, Juliana, and of course, thanks to Madam Chinasa, Uwanna. That's an IT powerhouse. Like I always say, for the mentees, you are getting really the best you can find of the IT world in Africa. Having someone like Ms. Uwanna on the program today. Thank you so much, ma. I mean, myself, I'm supposed to be a mentor, but I have also been thoroughly mentored by the presentation of Ms. Uwanna as well. So I thank you, Ms. Uwanna, and I also thank all the mentees who presented today. As always, like I tell you guys, for me, I benefit a lot from this because, yeah, it's not every day as a practitioner you are thinking about every area of IP law, but coming for a program to this program every Friday and hearing you guys touch on so many aspects of IP law. And then one of the things that really impresses me about this is the fact that your discussions are always touching on IP in practice in terms of IP as it applies in certain different industries. It's always wonderful. So I'll just quickly rush through my comments. Juliana, is there an indication of what time I have so that I just not pace myself?
About 5 to 10 minutes.
Okay, 5 to 10 minutes. Okay, so I'll try and move very quickly. So I'll just go through and just make comments on each person's presentation and some of my recommendations. So I'll start with Brandon. I think Brandon spoke on NFT. So yeah, NFT is wonderful subject. In fact, 2 or 3 weeks ago, I had an Instagram live chat on NFT, just discussing NFTs. You know, NFTs is technology just picking on something that has always been there and expanding it in a new dimension, giving it a new lease of life. So the simplest way I tell people to imagine NFTs is think about if you know what they call philatelists. Philatelists are people who collect stamps. So for instance, they collect stamps from all over the world, different ranges of time. So you hear, for instance, that somebody has a stamp collection that is worth $300 million. Maybe that collection, he has one stamp from 1897 that Queen Victoria used to post a letter to Prince Albert or something. Now, that stamp itself, the value of that stamp is maybe a pence or 50 pence or something. But because of the sentimental attachment to it, what it represents and all, people are willing to pay so much to get it. Another simple example is if Michael Jackson if somebody presents to you the gloves that Michael Jackson used the last time he performed Thriller, for instance, people are going to be willing. That glove on its own, if you go to buy it in the market, will be maybe tops maybe 10, 20, or 40, or let's say $100. But because of that attachment that Michael Jackson used this particular glove, you see people bidding to pay as much as $10 million for million and it's a JPEG. A JPEG is simply a picture file, just like any pictures you have on your phone. But that particular picture file was created uniquely, stored on that blockchain as an NFT, and then sold for that amount. So the idea is that anybody who owns that JPEG, that NFT file, as it were, knows that, look, to validate that I'm the original owner of this NFT, you can use the blockchain to check. So, for instance, if I come to you now and say, look, this is the last basketball that Michael Jordan used in his last game for the Chicago Bulls, you are going to ask me, how do I know? So you have to get a professional or an expert who will trace the history and say, yes, after Michael Jordan did that, they gave it to a children's orphanage in Miami. They sold it to one rich man in France. The man sold it to somebody in Kenya. The person in Kenya sold it to me. So that's the way we track to know that, okay, indeed, the particular ball I'm holding is that original one Michael Jordan is. But blockchain technology helps you do that verification without the need for an expert. Because once it is created on the blockchain, nobody can alter it, nobody can change it. So it's just a powerful use case of blockchain technology that we are seeing, in a new medium. Of course, there's a lot of hype around it, but even after all the hype settles, we are sure that it's going to point the way to a new way to use blockchain technology to solve a lot of problems. Think a practical solution. If I own a house, how do I know I own the house? I own the certificate of occupancy to that house. So the idea is, how I was not the first owner of that house. That house was owned by somebody who sold to another person, who sold to another person, who sold to me. So imagine if you put that information on the blockchain, then blockchain becomes a very good way to verify that information and know who exactly is the owner of an asset. So it just tells us that NFT technology is a pointer to powerful uses that we can have very soon for blockchain technology. Then I'll just talk quickly about Don's presentation on fast fashion. Yeah, and just say one of the ways, one recommendation that we could use to tackle the intellectual property challenges that arise in the fast fashion industry would be something they have in the EU called unregistered community design. So unregistered community design, I think they also have something in the UK. Essentially, it's just like industrial design, the equivalent of industrial design we have in most of our countries in Africa. But we know that registering an industrial design can be a little cumbersome because you are almost having to fulfill originality and all the requirements that the person filing the patent has to fulfill. And sometimes for fashion, it doesn't make sense to go and register something that will go out of fashion by the next summer or the next holidays that come around the corner. So unregistered design in the EU ensures that, look, once a person has used the design in commerce, whether you register it or not, there are certain rights you are given to protect that design. So that way, there's a lot of flexibility. You don't have to spend money registering a design that will go out of fashion soon. But at the same time, if people begin to perpetuate your design and copy it, then you also have some recourse against them. Then, look at Cecily's presentation on ADR. A wonderful presentation. ADR in the sector of intellectual property is very important because when it comes to intellectual property, you don't want to go to court and start revealing your confidential intellectual property information, for instance, trade secret. So using ADR makes a lot more sense. I would only point Cecily's attention to try and look up the World Intellectual Property Organization ADR Center. They have a very robust ADR center, offers a lot of these services, and it's something I think would also give you more context as to other reasons why it is preferable to use ADR for IP disputes. Then I would only throw another spanner in the works for CWC, and I would want her to go and do some more research on it. Now, in most jurisdictions, or I'll talk about Nigeria, Professor Paul Idonigi, who is a very respected professor of law and a very senior international arbitrator, in his book writes that if you look at the Nigerian Constitution, he says that intellectual property is one of the items that the Federal High Court of Nigeria has exclusive jurisdiction over. So therefore, he posits that when it comes to intellectual property disputes, arbitration cannot be used in that context because the Federal High Court has exclusive jurisdiction in intellectual property dispute. Therefore, you cannot arbitrate such disputes. So it's kind of a challenge, but I'll just give a hint on what I believe is the solution. The cases in India and in the US have held that, yes, indeed, intellectual property cannot be subject of arbitration. But there's a distinction there. Now, when it comes to intellectual property now, there are rights, intellectual property rights that are impersonal. And impersonal intellectual property right simply means a personal right that accrues from the ownership of intellectual property. So, for instance, the rights to license it and the conditions and terms that govern the licensing of your intellectual property. But however, there are also the rights to intellectual property that are in rem. The in rem rights now are the statutory rights to issue intellectual property. So, for instance, that distinction now means therefore that in the context of intellectual property, an arbitration panel can adjudicate issues of licensing, contractual terms of how you want to use your intellectual property rights. But what they cannot do, for instance, is to talk about the validity of the issuance of that intellectual property right. So, for instance, an arbitration tribunal cannot say Mr. Marx is a valid owner of this patent and not Juliana Imam. Or neither can they say that this patent is invalid. That's a declaration of invalidity of the patent, because that would be something that is reserved for the courts of the land, and arbitration cannot do. So that's one distinction that is important we understand. That's one distinction is important we understand. Then looking at the SMEs and IP, it's a huge issue. I think that's Paul's presentation. It's a huge issue, and that's what the World IP Day 2021 was all about. How do we get SMEs to plug into IT? Yeah, it's a huge challenge. Personally, when I started my career in IT, I was focused on working with SMEs. Believe me, it's not easy. I mean, it got to a point I really wanted to just give up on IT completely and just close down the IP section of my practice and just face other parts. But small businesses just don't appreciate IT. They think it's a waste of their money. You know, for instance, in Nigeria, about the only sector you see SMEs really serious about IT is in the food and drug industry, and that is just because they need a trademark registration before they are allowed to register their products in NAFDAC. But if you take that out of it, most of them will not even bother registering. And even at that, most of them are not ready to pay, or they just think, look, all I need is just enough to get me the NAFDAC registration and no more. They are not ready to protect it, to enforce it even when it is being infringed upon. So it's a crazy situation, but it takes what we are doing on the platform like this, learning how to break down IP as a subject and educate these SMEs and such kinds of people about the importance of IP. Help them sometimes even take up their cases pro bono, and then with time I believe it will spread and more SMEs will be interested in protecting their IP rights. So I'll quickly look at Rebecca's presentation. So she talked about computer programs and software. So yes, it's a huge issue when it comes to IP law. Now, what they have done, for instance, in the US, in Australia, and all is that when it comes to patents, they allow patent rights to be granted over computer-related software or computer programs. But the idea is that to understand what is patentable when it comes to the world of technology and computers, you need to understand how they have done that demarcation in the US and in Australia. They call them computer-implemented inventions. So what that is simply saying is that it's a regular invention. You have to test that computer program or software for all the features of a proper patent, and then it is just that it is computer implemented. So that way, it's easier to understand where patent comes into software and computer programs and where copyright comes in. So copyright protects the expression of how that thing is coded, which is different from the function. Copyright doesn't cover the function. So what copyright covers is just that it stops from copying your source code, but how it ultimately functions. If it is a matter that is proper for an invention, then you can get a patent over that. It's my opinion that even in Nigeria, you can actually get patent protection for a computer implemented invention, but it has to be a computer implemented invention, not just the expression of how you did the coding and all of that. So it's quite a distinction, and it's a technical field, but I would encourage Rebecca, just Google computer implemented inventions and read up more about it. You see more clearly the distinction between what you can protect by copyright and what you can protect by patents in the computer space. Then looking at Adetola's presentation on how to improve the African tech space and IP. One big okay, well, let me explain it to you now. We just talked about a computer-implemented invention. Now, when it comes to protecting computers in intellectual property, it's actually very complex. Most African tech companies are startups. They really don't have the money to get into that heavy duty. I mean, for instance, I think I read a report. The average time it takes to get a computer-related patent in the US is no less than 3 to 4 years. So how many SMEs? And of course, it costs a lot of money. So you can imagine how many SMEs and computer startups in Africa would have the money and the patience to go through that. But one simple solution done in a lot of countries, including the US, in France and other countries, to have what a lower level of patent right called utility model. So I believe it was somebody on this platform, I think from was it Angola or Namibia, who's mentioned that in her country that they have a utility model right. So one thing that is done in Africa is to encourage utility models. With utility models, we are getting a protection that is close to patent protection. It's a lot less than patent protection, but you get it without having to prove novelty and inventiveness, which are the two very difficult things to prove before you can get a patent grant. So if you do something like that, then it means that SMEs can quickly get some measure of protection without spending too much money. So that would be one quick way to help the African tech space when it comes to IP rights. So that would be one quick way to help with getting protection and getting the African tech space up to speed. Then I'll look quickly at so I think the last person was Daniel, who spoke about COVID-19, the IP waiver that the US has just supported for COVID-19. Yeah, it's a fantastic step the US has taken. And then one story that will help you appreciate this properly, and I would encourage you, Daniel, to try and look it up. Just Google the South African. I'm trying to use the keyword. You can find it. Okay, maybe I'll tell the story and then I'll find the keyword you can use to get more information on it. But what happened essentially was that as at 1998, South Africa had the highest HIV infection rate per capita in the world. And, they had these antiretroviral drugs coming to South Africa, but they were very expensive. South African government also about and say, look, our people are dying, and they are not able to afford this treatment. Yet, we have generic pharmaceutical companies in South Africa who can produce these drugs only if they are given a waiver or they are given a license to produce those drugs. Of course, the pharmaceutical companies who produce these drugs refuse to do that. So South Africa passed a law giving a compulsory license to its own pharmaceutical companies to manufacture those HIV drugs. So the thing created a huge uproar. South Africa, in fact, they had lobbied the US government to put South Africa on like a sanctions list for violating IP rights. It was a huge issue. Lots of anti-pharmaceutical company activists supported South Africa. So it was quite a tug of war. But what happened was that South Africa was lucky. At that time, the US Vice President then, Al Gore, that's President Clinton's Vice President, was contesting for the presidency. So because of the bad press it was causing for him, Clinton was forced to now backtrack and allow South Africa continue, just like what the Biden administration has done now in supporting the South African and the Indian resolution to waive IP rights on COVID vaccine. So it's an interesting area where politics and IP come together. So it's interesting. So I'd encourage you, Daniel, to read up more on that story of that South African HIV/AIDS issue. It gives more light on this. So we expect that with the waiver, now that more countries are able to produce produce vaccines, and it will become cheaper and more accessible and affordable for their citizens. But I'll just make a point there also to clarify something Daniel mentioned about the TRIPS flexibility. Now, the TRIPS flexibility, the TRIPS of agreement, like we all know, is the trade-related agreement on the trade-related aspect of intellectual property rights. So it's an agreement that is maintained by the World Trade Organization, WTO. So the TRIPS agreement itself sets a bar for respecting IP rights for all member countries. But at some point, member countries decided that, look, it's beyond issue of, and it also ties into the South African story I just told, beyond the issue of granting compulsory license. South Africa has some star companies in South Africa. So if they give a license to them, they can produce the COVID vaccine. But there are certain countries that don't have the pharmaceutical capacity to produce. So for instance, Nigeria would be one of them. Even if they give a Nigerian company the license to produce COVID vaccine, they may not be able to produce because number one, they don't have the technical capacity, the pharmaceutical capacity to produce. So the issue is that even if you grant a license to people to produce vaccines for you, ordinarily by ordinary rules of the TRIPS agreement, you cannot use that to export or import drugs. So for instance, you can't say Nigeria has granted license to an Indian company to produce COVID vaccines in India and export them into Nigeria. So the TRIPS flexibilities was made to block that, to cover that loophole and say, look, under the TRIPS flexibility, if a country fulfills the requirement, then you can grant a license to a foreign company to produce those drugs and import them into your country. So that's what the TRIPS flexibility is all about. And we expect that in addition to waiving IP rights, that the TRIPS flexibility will be important for most African countries because they don't have what it takes to produce these vaccines, even if they grant those licenses. So they need the TRIPS flexibility to be able to grant the license to foreign companies to produce on their behalf and import those products into their countries. And then finally, I'll just give one last thought on the question asked about Sophie's painting, that's the AI painting, who gets the money. It's a huge question because there's actually been a live case. It's called the Dabus case. Dabus is D-A-B-U-S. So I would encourage you guys to check it up. D-A-B-U-S, Dabus. What happened in Dabus was that a scientist, a computer scientist, invented a particular AI, and that AI invented some it was I can't remember exactly what it was now, but like a mechanical type of patent. He filed a patent, and in the place for writing the name of the inventor, he wrote the name of that AI, Davos. The Davos is actually a long acronym. I can't remember the full acronym now. He wrote that as the inventor, saying therefore that this invention was made by this artificial intelligence technology. But of course, in the US, they refused to grant him patent and said no. The US Act says only a human being can be an inventor for the purpose of patent. He also tried in the UK, he made the same fate. He tried in Korea, he also did not succeed. One of the things the court decided here was that look, a computer is not a human being, so it can't own property. Neither can he assign property. So because one of the questions asked was that, what if the man said, this invention was made by my artificial intelligence software, and the artificial intelligence software has assigned it to me, and I'm registering it on behalf of my artificial intelligence software? And he said no. The artificial intelligence software is not a human being. It cannot own property. Therefore, it cannot transfer property to you. So it tells me that just my thoughts about the answer to your question. The money would have to belong to the owner of the artificial intelligence. It won't belong because artificial intelligence cannot own money. But that is subject to even answering the question of whether the artificial intelligence actually can have any right to even be transferred. So thank you very much, Juliana. Sorry, I've overshot my time so badly.
It's very fine. Thank you so much, Mr. Marx. Like the wisdom pouring out from these sessions, it's just so much. And we are so grateful for Ms. Chinasa for coming and for Mr. Marx. Thank you so much. So quickly, Mr. Rama is here. That's the former WIPO director from New York. So I don't know if he would want to say something before we leave. Rama, do you want to say something? Okay, maybe he just came in to listen. So thank you so much, Mrs. Chinasa, for joining us. Thank you, Mr. Marx. Thank you, Rama, also for joining. Thank you to all the mentees. And I noticed that there's a Chiroma here, and I'm not sure where he's listening from, but thank you so much for joining. Thank you, Ma, for accepting the invitation. We really enjoyed your session, and we are very grateful that you shared these precious hours with us. Thank you, Mr. Marx, for always coming in and for always setting the bar higher and higher and higher. So my name is Juliana, Imam, and I would love everyone to have an awesome weekend and stay safe also from all the other things happening. Thank you, Ma. Thank you, sir.
Thank you.
Thank you. Take care,
Yeah, thank
everyone.
you. And guys, have a great weekend.
Okay, thank you. You too.
Everybody.
Okay, bye.
Thank you, everyone.
Bye, everyone.